The concept of shipwreck among national and international law. This article aims to investigate the juridical concept of shipwreck. Italian law doesn't provide a legal definition of shipwreck, although the explanatory memorandum on maritime code states that the wreckage of a vessel implies an intervening substantial modification of the physical consistence of the rest. On the contrary, English law classifies wreck in jetsam, flotsam, legend, and derelict, giving relevance to the abandonment of the vessel, sine spe recipandi. The significant and combination of objective criteria, physical standing, sinking, submersion or destruction of the ship, and subjective criteria, abandonment of the ship without the intention to return and resume the possession, will be examined in order to determine what the shipwreck is from a legal point of view. In particular, the analysis will focus on the concept of non-buoyancy and perishing of the ship derived from the Latin notion and on the notion of abandonment. Furthermore, the article will consider the definition of shipwreck given by international convention on maritime law, such as the International Convention on Salvage, 1989, the Nairobi International Convention on the Removal of Wreck, 2007, and the UNESCO Convention on the Protection of Underwater Cultural Heritage, 2001. Comparing the broader classification of shipwreck included in those treaties with the national definition. In light of the aforementioned analysis, the conclusion will consider if it is possible to individuate the lowest common denominator and some basic element of a truly international and possibly universal definition of shipwreck. Ships have their own life cycle. They are designed and built by men. They are given a name, a nationality, a classification, and a function according to their characteristic and purposes. Eventually, also vessels are destined to perish and to be demolished at the end of their commercial life. However, in some cases it might happen that the life of the vessel ends accidentally when, due to external and unpredictable circumstances, perils of the sea, they are reduced to a state of wreck. According to the definition given by Ulpian Navis Athenem, since the origin, the concept of ship has been strictly connected to its attitude to navigate as a consequence of its building structure and commercial purpose. Prima facie, with a vague and perhaps tautological definition, a shipwreck could be qualified as a structure which has lost its functional attitude and therefore it is not usable anymore for water transport. At this point, a terminological clarification must be done. In English language, the word shipwreck indicates both the remain of a wrecked ship and the destruction of a ship at sea by sinking or breaking up. In order to avoid any confusion in this paper, the term shipwreck will be always used in the first meaning. Furthermore, the word shipwreck will be used stricto sensu as referred to the hull of the vessel, be it the compact remain of the ship or the detached part formerly connected. In fact, wrecks in a more general sense can also be the appurtenance of the vessel, armament of military ship, or the abandoned load of the ship, whose destiny might or might not be linked to the wreckage of the hull of the vessel. The Italian perspective. An objective definition of shipwreck Italian Maritime Code defines ship as a structure directed to water transport and refers several times to the concept of relito or shipwreck without providing any definition of it. Although the Italian word relito derived from the Latin concept of reliquio navis, which literally describes the notion of a ship abandoned by its crew and passenger, the connection with the act of abandonment has been progressively lost. In fact, according to the explanatory memorandum on maritime code, the wreckage of the vessel implies an intervened substantial modification of the physical consistence of the good. Thus, the ship is lost when it loses the essential element which identify it as a vessel. In other words, when its physical consistence is altered in such way that it cannot be destined anymore to transport people or goods by sea. Such definition has been confirmed by Italian Supreme Court, according to which the condition of shipwreck implies the loss of all typical characteristics of a vessel, reduced to a complex of materials. The concept of shipwreck is a physical one, as it indicates the transformation of the ship as an object. In fact, a wreckage occurs when a ship ceases to be a buoyant, in other words, when it becomes unable or unfit to navigate, or, as Latin used to say, in ium statum, the wreckage implies the interruption, the physical perishment of the ship. According to same authors, the vessel becomes non-buoyant when its condition make navigation impossible, or when it has got such severe structural damages that make it impracticable due to excessive deterioration, or economically inconvenient to repair it, as it will require almost as much time and expense as to build a new one. However, it may be not evident which is the exact moment when the physical degradation transforms a vessel in a shipwreck. In fact, the derelictio is usually caused by a series of connected events which progressively degrade the structure of the ship until the loss occurs when the hull gets destroyed. Therefore, it may be argued that integrity of the hull is the paramount element to distinguish a vessel from a shipwreck. The physical dissolution of a ship may be caused by several reasons, usually by a sinking or breaking up, due to external causes, collision, storm, act of God, act of war, sabotage, or internal ones, fire, explosion, flooding, structural failure. In most cases, the destructive event implies as a consequence the sinking or breaking up of the ship, although such events are not always able to provoke the wreckage per sector. In order to have a derelictio, the alteration of the functional and structural element must be effective, permanent, and irreversible. On the contrary, there is still a ship and not a wreck when such ship is temporarily unagivable, but its buoyancy and can be promptly restored with proper repairing. For example, it is not the case of wreckage when a stranding or temporary submersion or even a sinking occurs and the ship fills with water, but it is not totally damaged and doesn't lose its physical characteristic. Similarly, an accident occurred in low backdrop where the ship can be easily recovered may be less susceptible of causing a derelictio. Sometimes the sinking is not the consequence but the cause of the wreckage. This happens when the structure of the ship, not yet permanently altered at the moment of the sinking, gets modified irreversibly due to the prolonged underwater permanence. The cause of the wreckage and the place where the shipwreck is located, sea, ocean floor, or shore, doesn't have any relevance in order to qualify the rest as a wreck. As a consequence, it is possible to assert that a shipwreck isn't anymore a vessel stricto sensu, but something different both physically and legally, as the classification of a structure as a vessel ceases when the ship has become a wreck. The connection between the objective and subjective element in the French legal system in defining the concept of shipwreck are the legal system, unlike Italian law, require not only an objective element, physical transformation, but also a subjective one. In order to have a shipwreck, the combination of two elements is required. Firstly, the structure must be non-buoyant. In other words, it must have lost its seaworthiness. Secondly, it must have been abandoned by the crew and left without surveillance or maneuvering. Thank you.